arbitrationagreements.org. We are going to delve into a very interesting and contemporary subject in the field of U.S. law, the intersection between text messages and hearsay. In this digital age, understanding how electronic communications can affect legal proceedings is quite crucial, so let's jump right in. But first, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save you a great deal of time and money. First off, I would like to clarify what hearsay means in legal terms. In a nutshell, hearsay refers to an out-of-court statement, brought in court, used for the truth of the matter it asserts. It's generally considered unreliable and thus in many cases inadmissible in court. However, it does come with its own set of exceptions. Now let's get into the meat of the matter. Text messages. You might be intrigued to know that as of last year, about 81% of Americans owned a smartphone. That's quite a significant number, isn't it? And as you can imagine, text messages have become an increasingly common form of communication. When it comes to legal proceedings, the ubiquity of text messages has naturally led to them finding their way into courtrooms as evidence. Now, one might wonder, how do text messages align with the hearsay rule? Well, let's unfold that. Text messages can be a bit of a double-edged sword in legal matters. On one hand, they can provide concrete evidence of conversations, acting as business records, and potentially providing an exception to the hearsay rule. Texts detailing fact-based statements, times, and transaction details generally stand on solid ground. On the other hand, text messages can also contain hearsay, statements made outside of the court that are presented to prove the truth of the matter they assert. However, it's important to note that the hearsay rule is not a blanket prohibition. In fact, text messages can sometimes be admitted as evidence if they fall under one of the numerous exceptions to the hearsay rule. For example, if a text message is used to show the state of mind of the person who sent it, rather than the truth of the content, it may be admissible. And let's not forget, the authenticity of the text message has to be proven first. This means establishing that the message was indeed sent by the person claimed to have sent it. This can sometimes be a challenging aspect given the rise in spoofing and other electronic manipulations that we've seen over the years. Interestingly, a study from 2018 showed that 77% of American adults believe that people are less likely to speak the truth in text messages compared to face-to-face conversations. This perception might be something to ponder upon, especially in the context of their admissibility and reliability in court. For more information, head on over to arbitrationagreements.org. Also, what do you think about text messages from a legal perspective? In general, should texts be allowed as evidence in court? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about the law.